Next, we have a calendar case, People of the State of Michigan versus Lonnie James Arnold.
Good morning.
Good morning.
Michael Brown on behalf of the people of the State of Michigan. I'm from the Monroe County Prosecutor's Office.
Welcome, Mr. Brown.
Thank you, Justice Ara. I will reserve 3 minutes for rebuttal and allocate 10 minutes to the Attorney General's office. The defendant is convicted of being a sexually delinquent person, indecent exposure, and he was sentenced to 25 to 70 years in prison. The sexually delinquent person statute originally stated that a court may give a sentence of 1 day to life. When the legislature passed the sentencing guidelines in 1998, they specifically included this offense and made it a Class A felony. The Court of Appeals and this court in the Bueller 2 decision held that a court may give a term of years, and to give a sentence of 1 day to life, there had to be substantial and compelling reasons to depart at the time. The legislature then, in House Bill 4597, or Public Act 300 of 2005, changed the wording of sexually delinquent person in 2005. It was changed to a violation is punishable for an indefinite term, the minimum of which is 1 day, the maximum of which is life. The defendant and the Court of Appeals are held and are arguing that this 2005 amendment to the statute controls and mandates a sentence of 1 day to life due to this being later in time. However, this ignores, in 2005, the legislature also passed a tie-barred bill, House Bill 4599, also known as Public Act 302. This amended MCL 777.16Q in the guidelines to correct the statutory citation for sexually delinquent person under the guidelines. This affirmatively shows that when the legislature passed Public Act 300, it was their intention for sexually delinquent person to remain in the guidelines as a Class A felony. And we should presume that they knew the state of the law at the time, that this allowed for a sentence of a term of years to be given. I'll waive the remainder of the free fire zone. The legislature has also showed its intention to have this as part of the guidelines by not including other sexually delinquent person statutes as part of the guidelines. There are multiple offenses where the sexual delinquent enhancement can be added. The legislature did not add gross indecency between male and male persons, male and female persons, female and female persons until 2006, after these 2005 amendments occurred. Sexually delinquent person due to sodomy to this date has never been added to the sentencing guidelines. I think when you look at the legislation the legislature has passed here, it has clearly been their intention for this offense to be part of the sentencing guidelines, and there's not anything to show that it is not part of their intention.
It sort of goes back to Bueller, but aren't the sentence guidelines doing a lot of work in this area that they don't usually do? I mean, can you think of other crimes that give a certain penalty that's pretty specific, where we've said, but if you go look elsewhere and sort of go through the Byzantine labyrinth of the sentence guidelines, Mr. Citizen, what you'll find is the penalty is actually a lot different than the one the legislature went to the trouble of specifying right after the offense itself?
This is a very unique statute. I can't think of anything else. But it is clear when the legislature passed the guidelines in '98, they wanted a comprehensive scheme to control sentencing so there was consistency, which was lacking at the time.
Well, would you just explain to us that it's not comprehensive because some even sexually delinquent person offenses aren't covered under the guideline scheme, so they apparently didn't accomplish their mission?
There are a few statute felonies that are not included, but the vast, vast majority are, including this offense. And they made it a Class A felony.
The sentence guidelines generally help us to understand what the minimum sentence range is before Lockridge mandatory. Now, not so, right?
Correct.
But as applied here, it just seems like it does more than that with sexually delinquent person offenses. Do you agree with that? Or am I off, or am I missing something?
Well, the guidelines were passed later in time than the sexually delinquent person. So I think if you look to the rules of statutory construction, that's why the Bueller court held that it should.
But it's not just telling us what the minimum sentence guideline range is. It's sort of breaking loose the logjam of it's no longer 1 day to life, but now you can do a term of years sentence, right?
Yes.
So it's kind of, for this offense, it has like an extra magical power, where it breaks you free from the constraints of the plain language of the offense itself. That just seems so strange and contrary to how we usually do things around here, at least to me.
It is very unique, but there is no other offense that has such a sentence. And the legislature clearly wanted to include it and give judges more flexibility.
Is it a choice for us that the guidelines, as Justice Viviano suggested, would be doing a lot of work, or, in the alternative, be a dead letter as it relates to this?
Well, this court held in Lockridge that for any offense that includes the guidelines still need to be scored, still need to be consulted by the court, and still need to be taken into account. What is the purpose of going through all these steps if it doesn't mean anything?
If the 2006, you described it as a later 2005 Tybar amendment, but if that amendment didn't specifically reference this offense, there would be no question that it's one day to life, right?
It would be a very tough argument to make otherwise, yes.
Okay. And so I guess that's my question. If we don't say that the guidelines modify that, then that amendment, which continued to reference this offense, would effectively be a dead letter. So it's a choice for us between the guidelines doing a lot of work, more than we typically would see them do, or the legislature just messed up and therefore we declare this aspect a dead letter.
Yeah,
you agree that's our choice?
Yes, unless you adopt the Attorney General's argument that this is a sentence of an indefinite term and it allows for a sentence anywhere in between 1 day to life. And I have to say, when I first read this statute 3 years ago and we started looking at this rarely comes up, this crime. That's the way I read it. But there is a series of case law from the Court of Appeals going back at least 30 years, and there's an order from this court that held otherwise.
In our statutes, I'm trying to think if there's any other case where life meant anything other than life. It was either life that was parolable or non-parolable life, but here we seem to have an indeterminate sentence life.
Yes.
Do you agree this is very unique?
Yeah, there's nothing.
Are you aware of it in any other aspect?
Nowhere under Michigan law.
Would that not weigh in favor of the Attorney General's interpretation?
I believe so. It makes much more sense to me. The other thing is,
so we've had two changes since Bueller too, right? The language has changed from may to is, so it's much more direct coming from the legislature with respect to what the sentence is, and the guidelines have gone from mandatory to advisory. So doesn't that flip the script entirely?
I don't think entirely, because I think it's clear with the tie barring of the bills that the legislature did intend for this to remain part of the guidelines and did intend to give flexibility for judges to give a term of
Didn't the
years.
analysis in Bueller hinge on the mandatory nature of the guidelines?
In Lockridge or?
In Bueller, which looked to the guidelines, right? This court's opinion in that case, I think 2007. Did
Yes.
it place emphasis and hinge some part of the analysis on the mandatory nature of the guidelines?
Yes. But even though that the guideline range, a court sentencing within it is advisory, The guidelines still do mandate doing certain things by law, and one of the mandates is that a court has to score the guidelines. And this is an offense where scoring is required by state law.
The guidelines still reflect the legislative intent.
Yes.
So you think the scoring of the guidelines alone is enough of a justification to do what I think Justice Zara described as the extra work we let the guidelines do just in relation to this one offense or family of offenses?
Well, this court has also held you have to consult the guidelines, take them into account. In Steenhouse, you held that a departure sentence must be reviewed for reasonableness under the Milborn proportionality standard. Every time you would give a sentence to 1 day to life, it will be a departure sentence because this is a Class A felony. How do you go through all this analysis if it's a foregone conclusion what the sentence is going to be? And there will be circumstances when this would not be a proportionate sentence. This is a very serious crime.
I mean, I agree it's a very unusual circumstance. When it appears when the legislature first enacted this statute in 1952, they had something very different in mind. They thought of these offenses as and conditions as treatable. Defendants would benefit from treatment. And that has all changed, but what hasn't changed really is the sentence. And, I guess when I look at these cases, I scratch my head and wonder, wouldn't it be easy for the legislature to bring some clarity to this by actually amending the statute and telling us what the sentence is, if it's not what they've already stated?
It would be, but there's a lot of laws that they could bring clarity to, definitely.
But to your prior point, as speaking as a former trial judge who has actually sentenced people to 1 day to life, there were circumstances in which, if we had discretion to do something different, we would have. And it seems to me that that's what the legislature is driving at here, that there may be circumstances where the alternative sentence of something other than 1 day to life would be appropriate.
I agree. If a sentence of 1 day to life is mandated, technically the parole board can parole someone on day 2 for extremely serious offense. Making it a Class A felony shows the legislature did not want that to be the only option. I'll turn it over to the Attorney General's office if there's nothing else.
Okay.
Thank you.
Good morning, Aaron Lindstrom for the Attorney General. May it please the Court. I think the plain language of these statutes shows there is no conflict between 335A and the sentencing guidelines because both of them allow a trial court to pick an indeterminate sentence. And the one initially gave broader discretion but set outer boundaries of 1 day to life. And the legislature, when they enacted the mandatory sentencing guidelines, constrained that discretion. But the very fact that these are included in the sentencing guidelines at any point in time, I would think seems to be strong evidence that the legislature thought there was more than one possible sentence that could be given for this offense. For example, the legislature for first-degree murder, there's only one possible sentence of life without the possibility of parole, did not include that in the sentencing guidelines. And similarly, for felony firearm, there's only one possible sentence of imprisonment for 2 years. Then that's not included in the sentencing guidelines. Yet here, the legislature did include this particular offense in the sentencing guidelines, which seems to suggest the legislature, at the very least, thinks there's more than one possible sentence that could be given under this statute. And that's consistent with the legislature's choice of using the phrase, the term "and," which this Court has repeatedly recognized, is something that's not specific, but rather is something that's indefinite, and that's an important ordinary word that everybody understands that conveys a plain meaning. And that, combined with the background context, where sentencing in general is an area where judges have, the default is that judges have discretion. It's very unusual for judges not to have some sentencing discretion. And so in that context, it seems especially appropriate to read this under the plain language where you're allowed to give an indeterminate sentence as long as it's at least a day and not more than life. That eliminates any conflict.
What do we do, Mr. I'm just curious what you think. What do we do with the the fact that, if you're right, the legislature apparently thought that was appropriate for some, but not all of the offenses committed by a sexually delinquent person. I don't know what to make of the fact that sodomy committed by a sexually delinquent person, I think everybody would have to agree, must be sentenced to 1 day to life, right? Because there's no argument to sweep in
Right.
that offense. What do I do with that?
I think that reflects a legislative judgment that they decided to treat that offense differently than other offenses. And there were other
Sexually
legal...
delinquent sodomists should be treated differently than sexually, I guess, yeah.
That's a
and so
choice
maybe that adds some support for the argument that the guidelines should do more work when the legislature decided they specifically apply to a sexually delinquent person?
Yes, I think the legislature can choose to punish one set of conduct differently, even if they're very similar. The legislature has the freedom to do that. I think that the fact that the ordinary way we interpret statutes is that differences in treatment indicate differences in the policy decision the legislature has made. So I think that fully explains that here. And here, it doesn't, again, the very point that it's in the guidelines seems to me to be strong evidence that they thought there was more than one possible sentence that could be given. And that's the ordinary English. The plain English, that's the way I read it when I first read it. There are cases we cite in our brief where it's read that way in the past. More recent cases, I think they're harder to provide insight into how people were reading it because there were flip-flops on whether the guidelines were mandatory or not. People were focusing on different language. I think the plain language is helpful. And if you read it the other way, there are problems that we identified in our brief, that if you read it as saying you get to pick an indeterminate sentence, but then you have to pose this specific one, that's imposing a Hobson's choice, which is not the way the legislature ordinarily operates, where they say you can pick any sentence you want as long as it's this specific one, and then they double down on that recognition that there is discretion by putting it in the sentencing guidelines, even though you have no discretion to exercise at all. And so the sentencing guidelines are a dead letter and aren't doing any work.
And you think that the switch from may be sentenced to is punishable is something what do we do with the switch from may to is?
I don't think that was the change that is about discretion. That change, because it is tie-barred as well, to the fact that they included it in 16Q at that time. That's a change that happened with the 2005-2006 changes to the law, where it was changed in 335A in 2005, but tie-barred to the 2006 change to 16Q. Put those two together, so I don't see how you could read it as saying may to is substantive and making it mandatory, when at the exact same time in a tie-barred bill, the legislature has once again said you should consider these factors when deciding what's the appropriate sentence to give for this particular offense. If there's only one offense, it doesn't make sense to put it in the guidelines.
If we conclude that the 1 day to life is not mandatory, what's the next step we should take?
If it's not mandatory, then that means it falls into the guidelines and the guidelines apply. And whether the guidelines are mandatory or not doesn't matter, right? Because the conflict, if the guidelines are advisory, so that just means that that 335 by itself gives a lot of discretion. The guidelines reduce that discretion, and you just follow this and apply the guidelines like you would any other offense where there is a range of possible choices. So I don't think Lockridge, if I took that to be a question relating to Lockridge, I don't think Lockridge changes it, because the point is it's discretionary at the outset. So the fact that Lockridge is also makes the guidelines also discretionary is reconcilable. That just means everybody recognizes there's discretion, and the legislature has narrowed that discretion in 1998 when they passed those. And so that's additional information that should be applied under Lockridge just like any other sentence, any other offense.
This interpretation you have is a little unusual, because you want us to interpret the minimum of which is 1 day to be the minimum of the minimum sentence guideline range, and the maximum of which is life to be the statutory maximum for the offense?
I think that the way you read the sentence as you work your way through it, it's an indeterminate term, and that is something that has a minimum and maximum. So at that point in the sentence, you realize there's going to be an indeterminate sentence. It's going to have some lower bound and some upper bound. And then the next part of the sentence if you want to explain that first part as opposed to contradict it, then what you do is that minimum means this is the minimum for those possible indeterminate terms, and the maximum is the maximum for the possible indeterminate terms. Then you get to pick.
Well, the maximum is not the maximum of the minimum guideline range, right? You're saying it's the statutory maximum is life, right?
Right. I thought it was the maximum of the top end of the indeterminate sentence. And I think that's the way it's been interpreted. If there are no further questions, I think our reading reconciles the two. It doesn't turn the guidelines into a dead letter where they have nothing to do. It gives the legislature credit for the plain language that they've used. It has a plain meaning where they've said you can sentence to an indeterminate term as long as it's at least 1 day, as long as it's less than life. Then you go to the guidelines, you apply the guidelines to see what the appropriate sentence is, and the judge has discretion under Lockridge to decide. He's not bound by those, he has discretion. And that reconciles all the statutes and the plain language. So we'd ask you to adopt that interpretation.
Thank you.
Thank you, Your Honor.
Good morning. May it please the Court. Marilena David Martin from the State Appellate Defender Office on behalf of Mr. Arnold. This Court should hold that if a person is sentenced as a sexually delinquent person under 335A2C, the only appropriate prison sentence is 1 day to life, and should also hold that the sentencing guidelines are not controlling. There are 2 ways this Court can reach that result. The simplest way would be to uphold People v. Campbell and the Court of Appeals decision in this case. In both cases, the Court of Appeals was correct in holding that the sentencing provision providing for a term of 1 day to life controlled over the sentencing guidelines. The second way to reach the proper outcome in this case is to give effect to the legislative intent in enacting the sentencing sexual delinquency statutes in 1952. The sentencing delinquency statutes were part of a larger statutory scheme that included several statutes, in fact, a definitional statute, but also included, sexual delinquency was also referenced in the then existing Mental Health Code, as well as the then existing Department of Corrections Act. At the time of the enactment, sexual delinquency was defined as a mental illness in the Mental Health Code. The exact language of 750.10a that defines sexual delinquency was mirrored as a mental illness in the Mental Health Code. In addition to that, and of significance, in the Department of Corrections Act, there were 6 sections that were enacted at the exact same time as the statute in this case, and all of those sentences referred to the sentence as, quote, an indeterminate term of a minimum of 1 day and a maximum of life. One section even referred to the sentence as, quote, 1 day to life. The provisions of the Department of Corrections Act also provided for intensive supervision, comprehensive treatment plans for people sentenced to prison as a sexually delinquent person, and authorized the MDOC to keep people in prison until they were no longer sexually delinquent. That is the purpose of the sexually delinquent penalty provision of 1 day to life. Under the prosecutor's position that any term of imprisonment can be imposed for a sexually delinquent person, that actually opens the door to more people being released when, in fact, they still might be suffering from sexual delinquency. The 1 day to life sentence prevents that because the parole board maintains control over when a person should be released. If that person is not amenable to treatment, they aren't going to be released and they're going to be incarcerated for the remainder of their life. The other important point to point out about statutory construction here is that the prosecutor relies on the 2006 amendment to 771.16Q, but there was also a 2014 amendment to 335A2C, and the legislature did not touch the 1 day to life sentencing provision. So that statute was actually last amended in time. Under a plain reading of the statute, the indeterminate term, the phrase "an indeterminate term" is qualified by the phrase that comes after it. The prosecutor wants to make the argument that "an indeterminate term" means anything possible under the sun, but then at least, as long as the minimum is at least 1 day and the max is no more than life. There's no other possible sentence besides a minimum of at least 1 day. There's nothing lower than that, and there's nothing higher than a maximum of life. So to read "an indeterminate term" as meaning any indeterminate term, so long as the minimum is 1 day, would render the phrase that we're talking about today completely nugatory and meaningless. It would give no meaning to what comes after the phrase "an indeterminate term." I invite questions at any time.
Counsel, what do you think about my question about what meaning should we give the fact that the legislature did include some sexually delinquent person offenses and not others? So sexually delinquent sodomists, everybody agrees, get 1 day to life. And the parole board gets to figure out if they should be released on day 2 because the cows are safe, or, year 49 because they're not. But don't we have to give some meaning to the fact that the legislature sort of picked and chose which offenses by a sexually delinquent person the guidelines should do some work for? I mean, doesn't that tell us something about what the legislature intended for this offense, since it was included and others were not?
Right. We do have to give some intent to what the legislature did here, but when you look at what the legislature decided to include in the sentencing guidelines, it looks as though, and I think the most logical explanation is that this is an oversight. There's no real logical reason for why a sodomist that's a sexually delinquent person should be treated differently than somebody who publicly exposes themselves.
Maybe there is, though. I mean, well, first of all, you don't see many opinions from this court where we say oversight. I mean, I'm not saying we can't, and I'm not saying it doesn't happen. You don't see that very often. So
absolutely. That's
not your best bet. But it's not, I'm not sure it's right? I mean, a rational legislator might think that someone who exposes themselves is more a danger to people than, the only kind of sodomist that can be constitutionally punished nowadays. So I don't know if that's right. I mean,
the other thing that I should point out too is that there could be other reasons for why the legislature included this offense continue to include this offense in the sentencing guidelines, other than to provide for the actual sentence of this offense. First, because this offense is punishable by an alternate sentence of 1 day to life, the guidelines might be very relevant to the parole board when they are deciding when a particular person should be paroled. So scoring the sentencing guidelines can have other effects than just establishing what the minimum sentence should be in a case. It also might be helpful to the MDOC when looking at the prior history or the characteristics of the offense, which are all captured in the PRVs and the OVs. The guidelines could serve those functions. I'd also like to point out to Justice Viviano's point that there is an offense of burglary using explosives, I believe, 750.112, where the legislature sets, that's the statute I could find closest to where there's an actual range, something close to a range. And in that statute, the legislature says that crime is punishable by not less than 15 years and not more than 30 years. And what's interesting about that offense is that it's a Class A offense under the guidelines. If you look at the Class A sentencing grid, the lowest possible minimum sentence you can get is 21 months. So there are some inconsistencies there, too, with that statute and what's acceptable under the guidelines. So reading the phrase "an indeterminate term" as legislative intent, that the legislature intended this offense to be punishable by the guidelines, even accepting that leads us to a lot of other inconsistencies. One, that the minimum term in the guidelines sets it at 21 months. It doesn't set it at 1 day. And it doesn't set it at 15 years like the burglary with explosive statute.
Do you know, just as an empirical matter, what judges do with that crime? What's it called? Burglary? What kind of burglary is it? Some special
Burglary with explosives?
Burglary with explosives. I'm not sure how many of those there are, but do you happen to know? Like,
I don't.
Are they getting 21 months or are they getting 15?
I don't know.
We don't know.
I don't know. I would imagine they are getting the 15, but I'm not entirely sure. Usually when the legislature sets a mandatory minimum, we see more sentences closer to that, but I'm unsure about this particular.
Your position is the mandatory minimums are followed, but in this case, where the mandatory sentence would be beneficial to the defendant, the argument is the guideline should trump the statute here. Am I following your argument?
No, Your Honor.
You're just pointing out that sort of anomaly.
Yeah, I'm just pointing out the anomaly here with including certain offenses under the guidelines that actually establish something close to a range that's not consistent with what the guidelines provide. The other, I think, important point here is to look at how the courts have consistently read the indeterminate sentence here in 335A2C since 1978 in People v. Helder. Since that time, our appellate courts have consistently referenced this offense as punishable by a definite term of 1 day to life. A defined term of 1 day to life. I couldn't find any appellate opinions that were published or from this court in which the court looked at this as a range of anything in between 1 day to life is acceptable. That has not been the reading of this statute since 1978. The other point I want to make is to say that I think there might be the perception, and we heard it from the prosecutor about potentially somebody getting out at day 2. That is not an accurate, it doesn't reflect reality of what actually happens to people serving 1 day to life. I unfortunately couldn't get any statistics from the MDOC about how many years of a minimum people serve before being paroled on these particular sentences. But what I did find was that in the case of People v. Kelly, a 1990 case, a seminal case on this issue, Mr. Kelly served 27 years on a 1 day to life sentence before being paroled. Mr. Campbell is on year 5. And that's because when you're sentenced as a sexually delinquent person, the MDOC undergoes extensive treatment and therapy. You have to complete sex offender programming, which is a month-long process. Often the MDOC requires a combination of cognitive, behavioral, group therapy for people classified as sexually delinquent. The nature of the 1 day to life sentence itself is an indication of how difficult it can be to determine the future risk of somebody whose character, the act that is penalized is actually an act of compulsion. This is one crime that our legislature penalizes compulsion, which is very unusual. It's not something that the legislature usually would penalize in a criminal code. And that's very important to analyzing what the legislature meant when enacting this statute. They didn't mean any term under the sun, because that would mean sexually delinquent people could possibly get paroled before they are treated. That's not what our legislature intended, and so this is not a more lenient offense. 1 day to life holds the potential, it has the potential to hold an individual in prison for the rest of their lives if they are not treated from the sexual delinquency. The last point I will make is that Lockridge, while I think important to the statutory analysis here and important to deciding whether or not the guidelines control, is not controlling to the outcome of this case. This case can find that based on principles of statutory construction, a plain reading of the statute, the fact that this statute is more specific, it's most recently amended, it's mandatory, the way that it's written, So this court can look at all of those factors and the legislative history to give intent to what the legislature meant for this particular sentence. Lockridge is sort of the icing on the cake in that it helps a little bit because it makes the guidelines advisory, and so it creates a weird result if the guidelines become controlling over a statute that is arguably very mandatory by the nature of the language. In closing, I'd like to say that this court should uphold People v. Campbell, and the only appropriate sentence following a conviction of sexual delinquency is 1 day to life, and this is the correct outcome based on over 65 years of having the statute on the books, and it is consistent with the legislative intent in enacting this statute and the way that this court has analyzed this phrase and this sentence throughout the decades.
Thank you.
Thank you.
I don't have anything additional to add. Does the court have any questions?
What about the argument that counsel just made about other statutes that have mandatory ranges where the guidelines would lead to a different result? Then we look to the statute as trumping the guidelines, right? You'd never argue, for example, that if the statute had a 25-year or 15-year mandatory minimum, that simply because it was a Class A offense and the minimum guideline range was 21 months, that 21 months was the appropriate statute, right?
Correct.
So is your argument the guidelines only work in this extraordinary way as a one-way ratchet?
This is a very unique statute. I have not analyzed that other statute in detail. Perhaps it would have the same outcome, but I'm not aware of any case law that has held that.
I mean, admittedly, it's a point that I hadn't considered either, but it's an interesting point, because if the guidelines trump the statutory penalties in a way that's favorable to the prosecution, then perhaps they should trump the statutory penalties also in a way that's unfavorable to the prosecution.
There may be some consistency there, but I need to see the exact language to see if it have the same outcome.
Any other questions? Okay, the case will be submitted. Thank you very much.
Thank you.